Hello, everyone, and welcome to the Anti-Doping Podcast, brought to you by the Partnership for Clean Competition. I'm your host, Dr. Marie McNeely, and today we are joined by our guest, Paul Greene. Listeners, Paul represents a variety of clients in the sports realm, including everyone from Olympic committees to athletes accused of doping. He's joining us today to discuss the legal process for athletes who might find themselves accused of wrongdoing. So, Paul, we're excited to welcome you to the show today. How are you?
I'm good. Thank you for having me, Marie. I'm a longtime follower of the Partnership for Clean Competition, and they do great work in terms of the grants that are provided. And I've been to the conference many times before, so excited to be on the podcast.
Oh, fantastic. Well, we're thrilled that you've been following the work that the PCC does, and we'd love to talk about your work today. So, Paul, can you start by just giving us a little bit of an overview of how you actually found yourself in this area of sports law in particular?
Sure. I went to law school in the early 2000s, and at that time, the sports law world and the anti-doping world were really revving up. The World Anti-Doping Agency was founded in 1999, and the code really went into effect worldwide in the middle 2000s after the UN Convention on Anti-Doping was passed. So I was in law school and coming out of law school right as the anti-doping world was really beginning, as I said. And I was looking for an article when I was on Law Review that was interesting to me at the time in 2005. And I listened on the radio to a story about a sprinter at the time named Tim Montgomery. And his case was the first case involving what was called a non-adverse analytical finding. It was the first case where somebody had been found to have committed an anti-doping rule violation without evidence of a positive test. And I thought that was a very interesting case. I delved more into it. I wrote an article about it that ended up being published in the Law Review where I was in law school. And I learned a lot about this world at that time, met a lot of people. And when I came out, it was a world that I was really interested in getting more involved with. I started doing cases pro bono in 2007, 2008, and it took me about 5 years. But by 2011 or 12, I had started to establish myself as an athletes' rights lawyer in the anti-doping space. And 2 years later, in 2014, I founded my own firm, and here we are almost 10 years later. So that's how it happened.
I love it. And I know over the years, you've taken all kinds of sports related cases, as we alluded to in the introduction. So can you talk about, I guess, the different categories of cases you cover, or just the different kinds of work that you're doing, and maybe specifically how much of your work is in clean sport?
Probably half of the cases that we do at my office, my firm, are anti-doping related. The other half would be cases involving allegations of misconduct in non-doping related, where athletes would be sanctioned by sports organizations. And sometimes we'll represent the sports organizations in those cases as well. We do cases involving good governance for organizations in the sports world, trying to help them with their bylaws to have a better system of governance, to hear the rights of athletes better and account for that better in their rules, that sort of thing. We do work with intellectual property, name, image, and likeness, which is a new area that's burgeoning with college athletes. Right of publicity is what it used to be called. We've done right of publicity cases over the years, breach of contract cases. But everything we do is sports related at our firm.
Oh, very cool. And I know you're based within the U.S., but your reach is quite international. So can you talk about the scope there?
Yeah, well, the World Anti-Doping Code is international. There's more than 200 countries that have adopted the code. And by virtue of the New York Convention, which is a convention that was passed in the 1950s that says if you do arbitration, you can really practice anywhere in the world as long as you don't go into a courtroom in that other country. I've handled cases involving athletes in more than 50 different countries. I've done cases outside the US, in Canada, Jamaica, Azerbaijan, which was probably the most far-flung place I've been for hearings. I've done many hearings in Europe, in Switzerland, which is the center for the Court of Arbitration for Sport, and a lot of the international federations. I've done cases in all over Switzerland and London as well.
Oh, very cool. And when it comes to representing athletes, you've represented kind of the gamut there, everyone from particular sports to horses. So can you talk about, I guess, just the different kinds of people that you've represented over the years of the different sports?
Well, that's really where I think my job is the most rewarding, is that I get to meet people from all over the world, cases involving athletes from countries where they don't speak English, but we communicate by way of translator. And I've been able to have an impact on people really globally. And that's the most satisfying part. And also feel like I learn a lot about different parts of the world. When you represent somebody from Uzbekistan, you pull it up on your computer and you learn about Uzbekistan. So you can have some sort of a conversation with the person about where they live and work. Likewise, with athletes I've represented from Africa, from Australia, New Zealand, South America. I've done many, many cases in Brazil. So it really has enabled me to be connected to the rest of the world. And I think that was the hard part of COVID, was that we weren't able to travel and everything went to Zoom. And I do think that athletes lose something when the hearing becomes a video hearing. So I'm hopeful that we can get back to in-person hearings.
Definitely. I think making that personal connection is important. But I guess backing up, Paul, and looking at the big picture, what role do you see the legal side playing in anti-doping?
Well, I think it's very important that both sides have quality counsel. Any legal system works only as good as the lawyers who are representing the people. I mean, you have the right under the World Anti-Doping Code and the rules. There's an international standard now that guarantees the right to a fair hearing. And part of that process is to be able to zealously represent your client. I mean, that's what lawyers are supposed to do. And then it's up to the arbitrator ultimately to make a decision. But I always try to make arguments that are credible. I always focus on the law. To me, that's what it's about. Arbitrators are always interested in what the law is. I'm always interested in trying to make procedural issues not ones that we have to go to an arbitrator for. I always try to work with colleagues on the other side on issues like discovery or when the hearing date is. I mean, those are not the issues that you fight about. And, it's never really a fight. I mean, to me, it's a debate about what the proper argument is. But I mean, there are plenty of legal arguments that can be made on behalf of athletes that if they're not made, the athlete will not get the proper treatment under the code. And so I think that's where you have the opportunity as a lawyer to really make a difference in someone's life.
Definitely. And as we've mentioned, you've covered a lot of different kinds of cases in your career. So are there particular types of cases that you're most interested in personally?
I think that the anti-doping area is so interesting because of the science and how it's ever evolving. But I've had cases with governance issues that are incredibly interesting in terms of learning about the culture and geography of different parts of the world that otherwise I would have never known about. So I'm not sure if one area is more interesting than another academically, if that really matters in terms of when a person comes to you, you're supposed to solve their problem. I mean, that's what it's about. They come to you, they have an issue, they're in a low moment in their life. If they're facing a disciplinary sanction or a doping sanction, and you have to figure out a way to either rescue them or guide them through as best you can.
Definitely. I think anti-doping law is quite complicated. There's a lot of nuance for sure. And many of your cases are brought before a body called the Court of Arbitration for Sport, or CAS for short. So our listeners might or might not be familiar with this body. So can you briefly explain its significance and some of the powers that they have?
The Court of Arbitration for Sport began in the 80s in Lausanne. It was initially created by the IOC, the International Olympic Committee. And for the first 20 years or so of the CAS history, there weren't that many cases, really. The anti-doping code didn't really have appeals anywhere that was universal, and FIFA didn't have appeals yet either. So it took, again, about in the last 10 to 12 years, CAS has started to become a true international Supreme Court for sports law with the evolution of anti-doping law, that now all appeals from around the world go to the CAS. And also FIFA, now all appeals involving football or soccer disputes go to the CAS as well. And so the CAS has gone from maybe a few hundred cases a year to several thousand cases a year. And the staff has gone from maybe 2 or 3 lawyers to 10 or 15 lawyers. And so it's really grown very quickly. These are the cases now, there's 4 divisions of CAS. These are the cases that have become the true international cases that are precedent setting around the world. And you've got 4 divisions with appeals, the ordinary division where 2 people would voluntarily go into an arbitration. And then you've got the ad hoc division, which just happened at the Olympics. They oversee disputes on site at an international event like the Olympics or the World Cup. And then you have what started about 2 years ago, the anti-doping division, which is now a first instance division that they'll oversee anti-doping cases for international federations.
Oh, very interesting. And maybe outside of a large event like the Olympics, for example, where there's a big time crunch, what does maybe a typical case going before CAS look like? Was there a particular place that you go? Is there a particular courtroom? What is that process like for you?
Well, Lausanne is the headquarters for CAS in Switzerland. It's on Lake Geneva, just about an hour north of Geneva. If you don't know where it is on a map, you can find it. It's a beautiful city, and CAS is located there. It just moved to a new headquarters, which is a much bigger spot. It used to be in an old chateau, which was a beautiful place to have hearings. And the new place is much more modern and bigger, and I'm sure will be more equipped for the new world. But its initial beginnings were you went to the chateau and it was in a conference room and you argued the case before some of the best panels of arbitrators in the world. I'm not talking about just for sport, but just generally. The people on the CAS, the arbitrators, are brilliant. As an example, Michael Beloff, who is probably the godfather of sports law, back in the 60s, he really began the practice area. He's a British lawyer, Queen's Counsel, and he's just one example of many that are CAS arbitrators. So you argue the case and then the decision is published. Normally, you'd have a 3-member panel. You could also have a 1-member panel, solo panel of arbitrators. But the hearings can be anywhere. I've had hearings in New York, LA, like I said, CAS hearings can take place anywhere in the world. And it's just a matter of the two parties agreeing on a location for the hearing. The case is still technically being heard in Lausanne, even if the hearing takes place somewhere else.
Gotcha. That makes sense. And I'm sure a lot of things have been virtual over the past 2 years, at least with the COVID situation. Is that correct?
Yes, it is. In fact, as an example of the difference of 6 years, in 2016, I had a big ad hoc division case in Rio, and I was there in person arguing the case. We were all there in person, the panel, both lawyers, the parties, etc. And that was a case of a woman named Daria Klashina, who was trying to compete in the long jump in the Olympics. And she had been declared eligible by her international federation in World Athletics. And then she was declared ineligible. She was Russian, but had moved to the United States and had been in the U.S. for many years in Florida. So that case was about whether or not she was eligible, even though there was no anti-doping rule violation. They were trying to keep her out of the games after the McLaren report. And we argued that there was no basis under the rules for that. And the panel agreed with our position and she was allowed to compete. 2022, and actually in Tokyo as well, the last summer, I had multiple ad hoc cases that were argued virtually by Zoom. I was sitting here in my office, and that's a big difference. I didn't feel as connected to the case. I don't know how that affects the outcome of it, but I just don't think it's the same when you're not in the room together arguing. It's hard to feel the person, see the person. It's just a different deal.
Certainly. And I know that CAS handles a broad variety of different kinds of cases. So can you briefly explain what kinds of cases would go before CAS versus an alternative route?
Well, in the appeals division, you'll primarily have 3 different kinds of cases. Anti-doping appeals of a first instance decision somewhere in the world, where the most normal case would be the athlete sanctioned for a period of time, 2 years, let's say, and they feel like the sanction should be shorter. So then they'll appeal. It'll be up to the arbitrators to decide whether or not the appeal should be reduced or the decision be upheld. The FIFA appeals are very, very distinct in terms of a lot of times it's disputes over money, whether it be an agent and a club, a player and a club, a player and an agent, but not always. I mean, there's the financial fair play rules. There was a big decision with Manchester City and UEFA a few years ago. That was appealed. There's also appeals in the CAS and FIFA involving code of ethics violations. Anything that really starts in the FIFA dispute resolution chamber will get appealed up to CAS. And then the third one are governance cases. I've had cases where you have one governing body suspending another body that's beholden to them. And then there's a challenge of that sanction, whether or not they have the power to issue such a sanction as an example. That's the appeals division. In the ordinary division, you really could have any dispute so long as it's sports related. You could have a contract dispute, a dispute over broadcast rights, really anything. The only requirement is that it be a sports related case. In the Olympic division, ad hoc division, most of the appeals are regarding eligibility, people challenging a spot that was given to another team by the International Federation and feel like they should have been in the Olympics instead of that other person. Those are the primary disputes, but really it's any dispute arising out of the games. And then, of course, the anti-doping division, first instance, every case is going to be an anti-doping allegation and whether or not that can be proved and what the sanction is.
So if cases don't end up with CAS, I guess, how are they typically resolved?
Well, only international level athletes are entitled to an appeal to CAS. If you're a national level athlete or a recreational athlete, your appeal would be normally to a national appellate body in whatever country you're in. So not every case gets the CAS. It depends on the level of the person. But a lot of cases never get appealed. The decision will just be whatever the first instance decision was, and that's it.
Gotcha. That makes sense. So I guess to walk through the process from the point where maybe a punishment is declared or the athlete is sort of accused of wrongdoing, how do we get from that point where something happens to trigger this case being started to how that case winds up in CAS's jurisdiction?
Well, I mean, the process is such that you'll start with a challenge or a letter alleging an allegation of some wrongdoing, and you'll go through the process, which will take several weeks, if not months. There are expedited procedures, but they don't always get followed. And you'll have a hearing at the first instance where both sides will argue their case. And then the appeal at CAS, interestingly, is what's called de novo, meaning you get a second shot, both either side. So sometimes you have to win 2 cases. Ultimately, if you're representing the athlete on my side, I've had cases where I've had to win twice for the athlete to be exonerated.
Oh, wow.
Gil Roberts is an example of that. It was a case in 2017. It was a crazy case, but Gil Roberts kissed his girlfriend who had gone to India and had taken back with her an antibiotic that had a banned substance in it. Interestingly, the banned substance has now been effectively taken off the list because it's got a threshold now of 200 nanograms, and he was way, way below that. He had an extremely low level. Anyway, we won the initial case, and then it got appealed, and we had to win the case all over again. So this can be a difficult process, particularly one for somebody who's not that sophisticated as a party to understand.
Definitely. And I know every case is a little bit different in terms of the timeline, but if you had to give a ballpark, how long do these cases usually take to resolve?
I would say 3 to 4 months.
Very interesting. And I know, Cass, the legal system is sort of a black box for a lot of people who are outside it. So when you're talking about your work or when you're interacting with the public, is there anything in particular that comes up commonly that you think people are misunderstanding about Cass?
I mean, I think there's this common belief that somehow a better system could be created than the one that currently exists, and that Cass should be blown up and create a new system. I mean, I always go back to the Churchill quote about democracy, that it's the worst system of government in the world until you compare it to every other system of government. Mm-hmm. I'm not sure what system will be created if Cass went away, which it's not going away anyway. It exists. And as lawyers, we try to live in the real world. I mean, this is the system that exists. Clients come to you and you have to represent them within the system. That's my job. So I never get as involved in legislation or policy because that's not really what I do. I mean, I represent people that come to our firm and ask us to represent them. So I think that there's this common misconception that somehow you're not going to get a fair hearing. I don't think that's right. I think you are going to get a fair hearing in most cases. There are criticisms of Cass, but you can make the same criticisms really of the federal court system in the U.S. Sometimes it depends on the judge you get. Sometimes you don't always feel like you would have been better off with a different judge, but you can't pick the judge you get in the First Circuit or the Supreme Court. You actually do get to pick one arbitrator. So I think that that's the common misconception, is somehow people feel like it's not a fair system. And I think it is.
Gotcha. I think that's important to clarify because our listeners might recall situations where decisions by Cass impacted athletes, such as even the recent ruling to allow figure skater Kamila Valieva to compete in the 2022 Winter Olympic Games. And I think these high profile cases can cause a lot of confusion and maybe frustration for the public, for athletes, and for other stakeholders who are involved. So, Paul, can you maybe talk us through a hypothetical case, kind of walking step by step and describing how the activities and input from all these different players that are involved, whether it's Cass, WADA, NADOs, international anti-doping agencies, athletes, everyone, their actions and their input factors into these cases to basically determine what the end result is going to be?
Well, the thing about sports law cases, particularly the ones at the Olympics like Valieva or other cases I've been involved with that are high profile, is that they fire people up. They're emotional. They get people involved and people care about the outcome and the result. And that's great. But the one thing I think people need to understand is that every case ultimately should be governed by what the law mandates. That's what law is about. Thank God our system of justice isn't like Twitter.
Right.
The wheels of justice are supposed to churn slowly. One of my law professors said that, and that's by design. You're supposed to have a stable system of law and a code that exists that's uniformly interpreted. The Valieva case, the arbitrators on that panel, I'm sure, were trying to figure out what the code said and what it mandated in terms of the ultimate decision. It wasn't about where she was from or anything else. I mean, all those other things came into the discussion, but that ultimately wasn't what the case was about. At least it shouldn't have been what it was about. I mean, every case should be about what the code says. You could have a debate about whether or not they were legally correct in terms of their interpretation of the code. But certainly once it was explained to me and I read the opinion, I could understand how they got to that outcome. I mean, other people don't agree with that legal interpretation of the code, but that decision was made because minors are treated differently under the code than other people. And it's uniform throughout the code. WADA said that we didn't intend them to be treated differently when it came to provisional suspensions, but it didn't say it one way or the other. And ultimately they read into what's called a lacuna or a hole in the code and said, we're going to fill in this hole. That surprised people, but it's not the first time that ever happened.
Certainly. So I guess, is this something where there's a way that you or your organization there likes to handle these cases where there might be differences in how you versus the other party are interpreting the code?
Well, I mean, that's where it comes down to, you have to make an argument that I believe is credible. And if it's not based on the facts of the law, you try to base it on an opinion or a reasonable interpretation based on past case precedent. You always try to find somewhere that supports a case. I remember one of my first cases ever wasn't a sports case. I was a very young lawyer arguing a case in state court. I was a breach of contract case, and I was passionately arguing this position. And the judge said, Mr. Greene, that's a very passionate argument, but other than Greene on contracts, what's your authority for that? And it was kind of funny. And it made me realize you just can't get up there and just say whatever you want. Mm-hmm. Judges want to rule based on something that's been decided in the past or some basis. I mean, It's hard to get a judge to rule on something other than narrow grounds. And I learned that when I worked for a First Circuit judge in law school, based on which the First Circuit is the court right below the U.S. Supreme Court based in Boston. And I learned judges like to rule on the narrowest grounds possible. And that has helped me as a lesson, I think, going through. You have to give the court a path to get to your ultimate result. It has to be a legal path there. It can't be just based on nothing. So that's what both sides argue is their interpretation and their path. And then ultimately it's up to the panel to decide.
Definitely. And I think anti-doping as a field is continuing to grow, continuing to evolve as we get more information, as we work through more of these cases, and as the science evolves as well. So thinking about the future here, what do you see, Paul, as the next big challenge for anti-doping law to hash out?
Well, I think right now, the biggest area from an athlete's side is how to handle these substances that are being detected in extremely low amounts, parts per billion, where WADA has accepted that you can't tell whether it's coming from environmental contamination or the tail end of excretion of an intentional ingestion. Scientifically, there's no way to determine it. And you have these situations where athletes are eating stuff, drinking stuff, getting contaminated by sex and by kissing. I mean, I've had all these cases. And how do you handle that? I mean, if you can establish scientifically that it's possible to get contaminated by way of unprotected sex, and that's how you determine the athlete was contaminated, why is that an anti-doping rule violation? Well, the standard is strict liability, meaning no matter how it got in your system, it's considered a violation. But that doesn't make sense from a policy perspective or otherwise. So the solution, or at least proposed one right now by WADA, is to put reporting limits in and say for certain substances, we're going to say if it's below this amount, we're not going to necessarily charge the athlete with an anti-doping rule violation. We have to do an investigation. The UFC has gone a step further, which I think is the correct way of doing it, and actually giving the athletes the benefit of the doubt. If they're below a certain level, they've switched the burden now and said the burden's on the anti-doping organization to prove that it was taken intentionally. And they're going to say, we're going to test that athlete, target test them, but we're going to give them the benefit of the doubt that one time. If it's a substance that we know can be from contamination and they're at that level, we're not going to make them prove where it came from. But I think this is the area that's become a very, very important area to get right, because the system only has credibility if innocent athletes are protected as well. It's not just simply steamrolling everyone. I don't think that adds credibility to the system. That's just my opinion.
Certainly. And I think as the scientific tests and the detection methods become more sensitive, this is becoming a bigger and bigger issue because we can detect even smaller and smaller amounts of a wide variety of substance. So definitely a challenge for the field going forward. And I know solving some of the big problems in anti-doping is sort of hindered by a lack of resources or maybe limited funding or staff or just the feasibility of some of these big issues you're trying to work through. So if we took away all of the barriers, Paul, is there one particular problem in anti-doping that you would want to solve most?
Well, I wish everyone had the right to counsel and that somehow there was a legal aid program out there for people from countries where they're not going to get that opportunity to have quality legal counsel. In the U.S., there's a legal aid fund through the U.S. Olympic and Paralympic Committee that's now in the U.S. OPC bylaws, but it doesn't exist like that everywhere in the world. So you have situations where athletes are faced with getting an unfair sanction and then having to appeal to CAS, and it's not free. To appeal to CAS costs money. At the very least, it's 1,000 Swiss franc filing fee, which for some people is unaffordable. So I really wish there was a way to provide access to quality counsel throughout the world. I think that everyone aspires to that, but you've got over 200 countries. It's very, very unique and difficult to provide access to everyone around the world in those different settings.
Definitely. And do you think maybe moving to more of a virtual format for some of these types of things might help?
I think that's the goal with the anti-doping division and with moving to virtual formats. But ultimately, you have to have people who are qualified and sophisticated making the decisions too. And what I see is in a lot of these smaller countries and smaller international federations, they'd rather over-sanction the athlete and give them a sanction that's too harsh because they don't want WADA to come in and appeal their decision. And really, realistically, WADA's only going to appeal if the sanction is too light, not too heavy. You can go back and look at the history of WADA appeals for sanctions when they're too heavy, and that's when almost it never gets appealed. So somebody could get 4 years for marijuana in a small country, and if they don't appeal and they just let it go, they're going to get 4 years. Even though I think WADA has a duty to step in those cases, typically they won't.
Gotcha. That makes sense. Well, I know we've covered a lot of topics today. Is there anything else you want to make sure our listeners know about you or your law firm?
Well, I think what separates us is that we really care about our clients. I mean, everybody does, but we try to make ourselves available all the time. We give every client our phone. We're messaging people constantly in different languages. And I try to impart that to the people who work in my office, my associate Kaiser, and the interns we've had is this matters to the people that are hiring us. And we really need to be there for them any time of day. I know that one of the things that really irks clients is when they're trying to get to your lawyer and they're not available. And so we always try to be available, and we really, really try to connect with people and empathize with them and understand their situation. This is a very difficult situation for people to be in. And sometimes just listening to them makes a big difference.
Absolutely. And if our listeners want to learn more about you and your work, Paul, what is the best way for them to do so?
They can reach out to us through our website, which is www.globalsportsadvocates.com. And then our email is on that website, and also our telephone number as well.
Fantastic. Well, listeners, definitely check out the website. Get in touch if you have any questions. And Paul, it's been such a pleasure to chat with you today. Thank you so much for joining us on the show.
Thank you. I appreciate you having me.
Well, it's been fun to be here. Listeners, great to have you here as well. If you haven't already, we would truly appreciate it if you could leave us a review on your favorite podcast platform to let everyone know what you think of the show. And listeners, please note that the Anti-Doping Podcast features a wide variety of clean sport experts, and episodes may include statements and or viewpoints that do not necessarily reflect the views or values of the PCC. Thank you, and we look forward to seeing you on the next episode of the Anti-Doping Podcast.